I'm Lauren Detzel, and I am the last speaker of the day. Yay! As I understand it, the last topic, because the medical marijuana bill didn't pass, you're not going to be discussing that today, so I'm it. I'm all that stands between you and the weekend. So I will try and make this painless. I will end on time. Okay. I can always stick around afterwards if anybody has any questions. But I know you all have had a wonderful couple of days, and I'm happy to be back here again. I've done this conference the last couple of years. I've been lucky to speak on estate planning, state taxes, business succession planning, and this year they asked me to talk about sort of the triumvirate of what I do, which is asset protection planning. Those three things together work very well. It's very hard to do good estate planning without doing asset protection planning, without doing business succession planning, so they all kind of come together. And I think this will be the last time you all have to put up with me for a while. So maybe we'll go out with a bang. I have to apologize. I've been under the weather. I have a voice today, not as strong as I normally have, but at least it has returned. And I'll apologize in advance if I start coughing. So I'm going to talk today about asset protection planning. And you all, some of you may remember, if you were here last year, or you know this anyway, that when I was speaking last year about business succession planning, I said there were really three risk factors that caused businesses to not be able to succeed to the next generations, because we know the percentages of businesses succeeding down to the second and third generation are very, very, very small. And the three risk factors that we identified last year were estate taxes, family disputes, and then this one, which is liabilities. Okay, and so we've talked about all of the others before, and this time we're going to talk about the way that we might be able to plan things so that we don't end up with creditors ending up with our assets instead of family members. So, the importance of estate planning. There are a lot of ways in which liability can arise. We can have contractual obligations, credit cards, consumer loans, real estate loans, personal guarantees, criminal penalties, civil penalties. Oh, I'm sorry. Let me back up. Let me tell you about the materials. In your materials at the very end is a very long, detailed outline that I did that covers in great depth everything that I'm going to talk about today. Much greater depth than what we're going to put up on the screen. So I leave that to you all to look at if you ever want to. It's got cites and quotes and all of that stuff in there. And what I'm putting up on the screen for you is just a short synopsis of what's in the outline. So I did not also copy the PowerPoint for you. That would have killed way too many trees. I killed enough with the outline. So the synopsis up here on the screen really just follows what we're doing in the outline and will allow us to just sort of follow along instead of the 50-page outline that you all have got. We're going to do it with just some PowerPoint slides up here. So everything that I'm saying is in all of the materials, and what's up here is just a short version of what's in your materials there. All right. So also we could have domestic relations proceedings, divorces. We have the big one, which are tort judgments. We could have liabilities come through for people who get injured on property or car accidents. We have vicarious liability, which is being liable for something somebody else did because of the way you own something, like you might own a vehicle and let somebody else use it, and they were negligent in the operation, and now you're liable for their mistake because that's something that we have in Florida, which is you're responsible for anybody that drives your car. Or it might be vicarious liability through a business that you own. It could be improper oversight as an officer or director of a company. Lots and lots and lots of ways that we could end up with liability. I don't have to tell you that. You all see all of the ads, the Morgan & Morgan for the people ad nauseum. We all know that there's lots and lots of litigation out there. And in fact, I checked this in 2010, and I was so depressed by this figure that I've not checked it since. In 2010, just guess how many non-criminal lawsuits were filed in the United States, filed that year in the United States. 20 million. Yes. There were a lot of foreclosures that year, okay? So that pushed the figure up, but that's a lot of liability. So we're going to talk today about how can we protect those assets. There are generally 5 ways that we look at to protect assets. The first one isn't one that we're really going to talk about today, but in any detail, but it's the first line of defense, and that is maintaining adequate insurance. That is always the first and foremost thing that you do to try and protect your assets, is to have adequate coverage and to have the right coverage. The trick is making sure that what you think is covered is what the insurance company thinks is covered. You certainly don't want to get down to the point of needing insurance coverage and the insurance company said, no, you're not covered because. And that because could be all kinds of things. It could be because we didn't say we would cover that. A good example of something that people like to check, should be checking is, what if the nanny is driving your kids in her car and has an accident while she's in your employment? Does your insurance cover that? Good question. Ask the company that. If you have transferred property that you have insured into a different ownership, whether it's to add somebody or to put it in an entity, and you don't tell the insurance company that now that property is owned differently, you might end up not having coverage. So it's very important that both with the underlying liability and to have those umbrella policies. The single most important thing that you can take, if you take away one thing out of here, is make sure you've got a personal umbrella liability policy, either personal or business or both. All right, so we're not really going to talk about that. We're going to talk about the other 4 areas that we look at in order to protect our assets. That's taking advantages of exemptions, protecting assets through the way we own it, using trusts, and using entities. So let's start with the first one, which is taking advantage of exemptions. Assets, there are certain types of assets that are exempt from the claims of creditors just because of the nature of the asset. And there's both state exemptions and federal exemptions. So if you get into trouble and you owe somebody money, you can owe them money as a result of a judgment that is rendered against you in local court, in state court, okay? Or it's possible that we could be talking about bankruptcy, which is federal court. So both of these are very important. And the federal bankruptcy law has an option that each state has to whether they're going to allow in that state for bankruptcies for residents of that state the federal exemptions, which are very sparse, okay, or whether a state can take the state exemptions and apply it in federal bankruptcy court. And most states each state can make an option whether to apply the federal law or the state law, state exemptions. A few states allow you to choose, allows the actual debtor to choose which it is to be. Florida uses state exemptions, which is very much to our advantage because our state law exemptions are significantly greater than the federal law exemptions. And so we're going to talk about those and look at primarily the state law, but how the federal law can interplay with that. So the first one is Homestead. And that's the one we all know a lot about. That's the one you hear the most about. I'm not talking about the ability to reduce your real estate tax because it's your homestead. I'm now talking about a constitutional provision that came in the 1800s that was designed so that you couldn't get thrown off of the homestead by creditors. So we have a provision in our Constitution that says that the homestead is protected from forced sale by creditors. And it's important to determine if we've got a homestead and what the limitations are to that, because Florida happens to be one of the few states that has an unlimited exemption. You can have a $10 million house and it is free from the claims of creditors, right? Almost all states that have any homestead exemption have some cap on it. And you'll see that there's a federal cap in just a moment. Now, it is not exempt from everything. It is exempt from, it's not exempt from liens for ad valorem tax or the mortgage that's on the property, or for people who render services, labor, or something to repair or improve the property. And of course, it's not exempt from federal tax liens. Nothing is exempt from federal tax liens, it seems, or very few things. And there's a size limitation. If you live outside of a municipality, you don't live inside city limits, then 160 acres, the house and 160 acres around it, can qualify for a homestead. Now, they're not going to qualify for a homestead if you run a business on that property. So if you've got a ranch as part of that property, okay, it is possible that a creditor may say it's not all exempt from homestead because, after all, it's supposed to be your home, not a business exemption. If you live within a municipality, it's half an acre, the house and half an acre. And if your property is greater than the size limitations, then the court has the option, and they could actually subdivide, if they could subdivide the property and take the house and half an acre of property and keep that exempt. Or if that's not possible, they will order the property to be sold and then will prorate the proceeds, and some portion of that will be exempt. This is during lifetime. Well, what happens to the homestead at death? Okay, so let's suppose that a decedent dies and has the homestead was protected during life. Okay, but now they die and they've got big debts against their estate. Okay, they had guaranteed real estate loans out there. They had judgments against them. Whatever. Is it protected? Well, the first thing we have to look at is who gets the homestead upon death, because Florida also has some restrictions about where a homestead can actually go when somebody dies. If a decedent owned the homestead themselves, not in joint names, okay, with a spouse, so it's not owned jointly, it's not owned tenants by the entireties, but they own it themselves, then believe it or not, that person can't just give it to anybody they want to. All right, and that's because that same Constitution provision that says we want to protect it for the homeowner says we also want to protect that house for the wife and kids. And back in the 1880s when this came in, it actually said wife. Now at least says natural person. And so they don't want the spouse and the children to be thrown out of the house at death because of the debts of the owner of the property. And so what they say is that the property can't be distributed except in a certain manner. So it depends upon who survives that decedent. If the decedent is survived by a spouse but no children, then the homestead can be devised to the spouse. If they're survived by a spouse and at least one minor child, okay, then the homestead can't be devised at all. Okay? It has to descend as a life estate for the spouse and a remainder interest to the lineal descendants, all of them, whether they're adults or minors. Right? That's really awful to end up with a house being owned partly with a life estate to the spouse and a remainder interest to children, some of whom might be children from a prior marriage. Right. So we at least brought in a couple of years ago a new provision that allows the surviving spouse to make an election to have the house, the homestead, treated as a tenancy in common, with the spouse owning one half interest and all of the lineal descendants owning the other half interest. So they could make that election if they want to do that. If the decedent is survived by a spouse and lineal descendants who are all adults, then it can be devised outright to the spouse, but not to anybody else. All right? And if it's not properly devised to the spouse, then it goes life estate to the spouse and remainder interest to the lineal descendants with that same election to treat it as a tenancy in common. if the decedent is survived only by a minor child, okay, no spouse, then it can't be devised at all. All right. It is going to go to all the lineal descendants, which means that, when the minor child turns 18, they're going to get this, it's going to have to go through a guardianship until then. And then when they turn 18, the house will be owned by the minor child and the other lineal descendants. A couple of years ago, we also brought in a new provision called a Homestead Trust. And if there's anybody out there, or you all have clients or family members who have a valuable house and they own it themselves, not with a spouse, and they have minor children, you may want to look at doing a homestead trust, which is a way to protect that house so that it doesn't have to go into guardianship and doesn't have to be distributed out to the child when they turn 18. Homestead trust. Okay. If the decedent isn't survived by any children, if they're survived only by adult children, they can do anything they want to with it. Okay? Can give it to anybody they want. And important with this is then if the homestead ends up being given to heirs, okay, and heirs are defined as descendants, ancestors, siblings, nieces, nephews, uncles, and aunts, if that's where it goes, then it's protected from those debts of the estate. Remember we said the decedent died with a whole lot of debt and a lot of value in the homestead that he wants to protect. Well, if it ends up in the hands of an heir, then it's going to be protected against those creditors of the decedent. Okay. All right, and what if you sell the homestead during lifetime? Are the proceeds exempt? Yes, they are, as long as the owner intends to reinvest into a replacement homestead within a reasonable period of time, and they keep the proceeds segregated in a separate account, and they don't commingle it with anything else. If it turns out within some reasonable period of time, and that could be years, it's not reinvested, then it may lose its homestead protection. But certainly for at least a year or two, it's going to be able to be held in an account until the replacement homestead comes in. Now, what about federal bankruptcy law? Okay, it sits on top of the Florida law when we talk about exemptions. And there's some extra provisions if you're in bankruptcy court because they don't want you to be able to do forum shopping. So if they don't want creditors, debtors to be able to do forum shopping, to travel around the country and figure out what's the best place to live in order to avoid creditors. And so there's a requirement that if you have not lived in the house, you acquired the homestead less than 3 years and 4 months prior to filing bankruptcy, then you get the federal exemption, not the state exemption. So if you buy the house within 3 years and 4 months before filing bankruptcy, then you're stuck with the federal exemption amount, which is $125,000, not unlimited. Okay? And that's adjusted for inflation, and it's currently about $155,000. And also, with respect to all the exemptions, right, you have to have lived in a state for essentially 2 years before you can use the state exemptions. And that can be very important, not just for homestead, but for the rest of these exemptions that we're going to talk about, because Florida has some significantly better exemptions than either the federal exemptions or other states. So let's now move and talk about the second category of exempt assets, which is retirement accounts. And Florida has an unlimited exemption for any money in a qualified plan, whether it's a Roth IRA, a 403B, a regular 401K, a retirement plan, whatever it is, okay, it is exempted. In addition, funds in an inherited IRA, and this is going to be important in just a second, are also protected in Florida as a result of some recent legislation. And what is an inherited IRA? What do I mean by that? What's the difference? Okay, that's really important because, as you'll see in just a second, Florida is one of only 7 states that has an exemption for inherited IRAs. An inherited IRA is where I have an IRA, I die, and I name my child as the beneficiary, and my child says, I don't want to cash it out, because if I cash it out, I'm going to have to pay all the income tax up front, and then it's no longer earning income tax exempt. I want to leave it in the IRA and just let it continue to grow tax exempt, and I'll get distributions out of it on a year-by-year basis, pay the income tax as I get the distribution, so I can defer income tax and I can keep it growing tax exempt. That's an inherited IRA, right? And unfortunately, let me tell you, the bankruptcy law, the federal bankruptcy law, has limitations on what's exempt. Florida is completely unlimited. The federal law says that traditional and Roth IRAs are limited to $1 million being exempt. That does not include anything that's rolled over from a pure retirement account. If you rolled your 401k over to an IRA, that is not included in the amount that's in an IRA. And under federal law, inherited IRAs are not exempt. Right. There is a recent case that just came out a few months ago. The United States Supreme Court settled a dispute among the circuits about an inherited IRA. So mom leaves an IRA to child. Child has creditors, right? Creditors want to get the inherited IRA, right, after mom dies. Do they get it? Right? Can they receive that if mom says, I leave it to my daughter? Well, unless you're in Florida or one of the 6 other states that have a state exemption, the answer is yes, the creditors can get it. Because the Supreme Court said in a unanimous decision, they rarely agree on anything like that, but they said that it is not protected because the protection at the federal level is designed for retirement funds. And they read into that retirement funds of the participant. Okay? And when it gets down to the daughter, they weren't her retirement funds. They were mom's retirement funds. So we're not going to let it be exempt. But if you're in Florida and your beneficiary is in Florida, if the person that owes the money and the person who's getting it is in Florida, you're in luck because it's completely exempt. If, however, if, however, the beneficiary happens to live in one of the 43 other states that does not protect it, it won't be protected. Right? And so if that's the case, what do we want to do? We want to be concerned about the beneficiary designation then. All right, beneficiary designation is very important for IRAs, life insurance, annuities, all of these exemptions, because you have to make sure that you don't lose the exemption at death. Remember we talked about a decedent who'd piled up the debt and had exempt assets during their lifetime. The creditor couldn't get their assets during their lifetime, but now they die. Can the creditor get the assets? Well, if you have an IRA, if you have a retirement plan, and you have made sure that you have the proper beneficiary, then the answer to that is no. Okay? If you don't have a beneficiary or you name the estate as the beneficiary, then all of the assets are going to, all of that what would have otherwise been exempt is going to be open to the creditors of the estate. So as long as you have a designated beneficiary that is not the estate, it's a testamentary trust under the will or a revocable trust, then you're going to be okay. Right? And that's the same for all of these exemptions, whether I'm going to talk about life insurance and annuities in a few minutes and IRAs and retirement accounts. But what if we've got that inherited IRA now, okay? And we've got a daughter who lives in Indiana, okay? And Indiana isn't one of those states that protects it. And we know that she's got creditor issues. The last thing that we're going to do is name that daughter as the beneficiary of our IRA, because that means her creditors are going to swoop in the moment that mom dies and take them. So instead, what we're going to do is we're going to try and put it in a trust. We're going to change the beneficiary from being the daughter to a trust. And you're going to see later that we're going to talk about a lot of different kinds of trusts that are very protective for asset protection purposes. But here in particular, we want to look at 2 specific types of trusts that can be used as designated beneficiaries of retirement plans or IRAs. And that's a Conduit trust, and the other one is an accumulation trust. Either one of these trusts, right, if you qualify as one of these, will be a designated beneficiary. And why is that important? A designated beneficiary is important because if it's a DB, then the distributions can be made during the beneficiary's entire lifetime. Right? They don't have to come out at 5 years after the date of death like they might otherwise have to. So you can put it in a trust and provide for a lifetime payout for your child, and it is then the income tax is paid each year as a distribution is received. And if you make it be one of these conduit or accumulation trusts, then it can be protected. It's not outright to the daughter, and it doesn't go to her creditors. What's the difference between these two? Conduit trust and accumulation trust. Well, a conduit trust is one of these types of special trusts that says that any distributions from a retirement plan have to go to the designated beneficiary, the beneficiary of the trust, right? And we like conduit trusts because they're easy to create. It's almost impossible to screw up a conduit trust. Right? But the problem with a conduit trust is that we're not sure that you can use the language to or for the benefit of a beneficiary. And we're concerned that it's possible that instead of the trustee being able to make distributions out of the money, the distribution that comes every year from the IRA, okay, for the benefit to pay the bills of the beneficiary, if they actually have to distribute that money out, then the creditor could be there quickly on the spot to get the funds if they come out of the trust to the beneficiary. In an accumulation trust, you don't have to do that. You're not required to make distributions. You can accumulate the monies that come out of the IRA and pay them out whenever it is otherwise safe to do so. But an accumulation trust is a smidge more difficult to draft and make qualify. Not impossible by any means, but a little bit more difficult. All right, other exempt assets. We have 529 plans are exempt in Florida. We have health savings accounts are all exempt in Florida. We have educational IRAs that are all exempt in Florida. Okay, and you know, this is a state-by-state determination. Florida, as I said, is one of the best states for these types of exemptions. Now, what about life insurance, right? The cash surrender value of a life insurance policy is exempt during the life of the insured, but only if the policy is on the insured. So if I own a policy on my life, the cash surrender value is protected. If I own a policy on my husband's life, the cash surrender value is not protected, and my creditor can come and take the cash surrender value of that policy. Okay? The proceeds paid at death are protected. Right? But again, you've got to be really careful that you don't end up with the proceeds in a pot like the estate that is otherwise subject to the claims of creditors. So you want to make sure that you've got a designated beneficiary that is going to receive this, not let it fall into the estate. Never, ever name the estate as a beneficiary. Okay. Annuities, the same thing. Cash surrender value, death benefit, completely free. All of these are unlimited exemptions. And again, we have to be concerned about beneficiary designations. The last exemption that we're going to talk about is the wages exemption. And this is if you have a head of a family and they have earnings, sorry, and earnings is basically wages, bonuses, commissions. It's not distributions of profit, okay, from a business. But if they have wages and they're a head of a family, they're pretty much exempt as they earn them. But the question is, what if we don't spend them all, okay, and we've got a creditor out there and we just stick them in an account, the wages in an account somewhere, can the creditor get it? Well, not if you are careful and you have an actual wages account, right? And a wages account is something that you essentially designate as that. I mean, I tell my clients to call it the Lauren Detzel wage account, okay? And you deposit your check directly in there. You make sure you do not commingle it with anything else. So the only thing that can be in that account is ever wages. And so while it's in a wage account, it's protected. But unfortunately, they changed the law, and every 6 months we have to pull assets out of the wages account. It can only stay in there for 6 months. So after 6 months, we need to pull it out and take that account down to zero and start over again. And we can, it's going to be important, it's going to be treated as an exempt asset, and it can be reinvested in any other kind of exempt asset. So at the end of your 6-month period, that excess money can then be protected somehow else. You could pay down your mortgage on your house. You can put it in an account that we're going to talk about in a second with the spouse, a tenancy by the entireties account. You can use it to buy insurance, annuities, whatever. You can transfer it from exempt to any other kind of exempt, right? But you got to take it out after 6 months. All right, so the next thing that we're going to talk about, we just talked about exemptions. The next thing that we're going to talk about is owning assets in a way that protects from creditors. And primarily what we're talking about here is something called tenancy by the entireties. Raise your hands if you all have heard of tenancy by the entireties, please. Okay. Most everybody knows about tenancy by the entireties accounts and ownership. Tenancy by the entireties is sort of a legal fiction. Okay? It says that if we meet these certain requirements here, then it will be treated as though each husband and wife, each of the husband and the wife, own 100% of the account at the same time. So I own 100% and my husband owns 100% of the account. And why is that important? It's important because if I own 100% of this account and my husband has a creditor, that creditor can't get any of the account or any of that asset because they'd be taking my asset and I don't owe them anything. Okay? So because of this fiction of each of us, each of the married couples own the entire thing, tenancy by the entireties assets are protected from creditors of just one spouse, not protected from creditors of both spouses, right? But it is protected from the creditor of one spouse, and we have to meet these certain unities here. They're here, and I'm not going to go into them. It's pretty easy to meet, actually. And there's also a joint tenancy with right of survivorship type account. And how is that different from a tenancy by the entireties? It's different in that it can be with somebody other than marriage. Oops, I should have gone back and shown you that one of the unities is of marriage. So tenancy by the entireties accounts can only be between husbands and wives, okay? Joint tenancy with right of survivorship can be between anybody. Does not have to be husband and wife. But unfortunately, it's not treated as though each person owns 100%. It's treated as they own their proportionate share. And what does that mean? That means a creditor of either of the joint tenants can get that joint tenant's share. So if I own it 50-50 with my husband as a joint tenancy with right of survivorship and he has a creditor, they can get his half. They can't get my half, but they can get his half. If I owned it as a tenancy by the entirety, his creditor couldn't get any of my asset, couldn't get any of that account. All right, now, what is the problem with tenancy by the entireties? Okay. The problem is that it is severed if one of the spouses dies or there's a divorce. Okay. It's got to be husband and wife. There's got to be a marriage. So if the wrong spouse dies first, okay, the spouse that doesn't owe the money, okay, dies first, now that asset is owned 100% by the spouse that owes somebody money, and they can come and get the asset. So that is, tenancy by the entireties is great as long as we have a marriage. Okay, obviously divorce terminates it as well, right? And if we had enough time, okay, if we have a spouse that's terminally ill and the other spouse is the one that owes a lot of money, right, we want to do a little planning in advance. Okay? We want to terminate that tenancy by the entireties so that the spouse that's going to die owns it all, and then we'll put it in a trust when the spouse dies for the benefit of the husband and protect it. Okay? But unfortunately, we have to have a little advance warning about that death event, and we don't always have that advance warning. Right? And so it is, I'm going to skip some of this stuff here, okay? And so, All right, let me tie this in. And we're going to come back and talk about tenants by the entirety. So I'm going to come back and tie tenancy by the entirety and death of a spouse together in just a second. But let's talk about ownership through of jointly owning things that can cause liability, like cars and boats. Okay. Florida has is what we call a vicarious liability state, and that means that if I own a dangerous instrumentality like a car or a boat, and I am responsible just because I owned it for any negligence in the operation of that vehicle, whether I'm driving it or not. So if anybody's behind the wheel and they cause a problem, I'm on the hook for it because I'm the owner. So now what if I am stupid enough to put my husband's name and my name on the car? Okay? That means now that we both own this, and no matter who's driving it, we're both liable. So what did that just do for all of our tenants by the entirety wonderful planning that we did? Now we've got a debt of both of us. Okay? We had our teenage son driving, and we both owned the car. So now we're both liable, and they can get the tenancy by the entirety's property. Okay? Not a great idea. So the cardinal rule is always to have he who primarily drives the vehicle own it. Right? Do not cross-own or co-own vehicles. If you drive it, you own it. If your spouse drives it primarily, have the spouse own it. That at least lessens the risk down some. And count the days until your child turns 18 and the child can own the car. As my children each turned 18, title transferred immediately to the child so that I was no longer on the hook for their driving. All right, so now one of the things, let's go back to tenants by the entireties, and the wrong spouse dies, okay? And now we've got a lot of assets owned by the person who owes money. Well, if we didn't have it in tenants by the entireties, but instead, at a time when we didn't have a creditor, when we weren't under the gun, okay, we transfer ownership to our spouse, right? And then the spouse owns this asset, right? And then the person that we're worried about who has the possibility of having creditors, a doctor, the real estate developer, the business owner, okay? If we then have the spouse of that person own it, and it didn't get transferred there at a time when we actually had a debt, so we don't have a fraudulent conveyance, we'll talk about that at the end, then having that owned by the other spouse is going to protect that asset. Right? So that's why you see a lot of assets owned by each other. There's good state tax reasons for that as well, but asset protection that's why you will find most of the doctors, in Florida whose spouses own everything. Okay? Or a very large portion of the assets, anything that's not exempt. Right. But now the person whose assets it is and says, I'm not real comfortable with just giving my spouse all these assets because he or she may not do what I want them to with it. Maybe I want a little more control over that asset. So what do? Well, we can put it in a trust. It's called a QTIP Trust, Qualifying Terminable Interest Property Trust. And we can put it in a trust for the surviving spouse, and we can be the trustee. Okay? So we can be in control. Husband can be trustee, put it in trust for the surviving spouse, okay? And it's free from the creditors of the husband. Okay? And it's free from the creditors of the spouse because we're going to see in a few minutes, we did this trust in a way that was done properly and it should not be subject to creditors of the spouse, and we weren't terribly concerned about her creditors anyway. Right? So now that sounds great. That's wonderful. As long as they're alive, right? What happens when the wife dies? Uh-oh, she dies, and now husband says, well, I'm real happy that the creditors didn't get it, but I'd kind of like to have it back, wasn't really counting on all of that going down to my kids just yet. So what can we do? Well, Florida luckily solved that problem, and you can have the assets stay in that trust now for the benefit of the husband, the person who created the trust. And it's still free from the claims of the husband. So it is a lifetime QTIP that is for the benefit of the surviving spouse, for the spouse, and then can actually come back and be for the benefit of the donor to begin with, and it's protected from creditors. Okay. And we can also put things in trust, and we're going to talk about trust in just a minute. So we know that we can have assets owned in a way that can protect tenancy by the entireties in spouse's name, right? Are better than joint tenancy with right of survivorship, obviously better than in individual name of a person that we're concerned might have some debts. All right, so now let's talk about, I'm trying to remember when we started, so make sure that I don't go over. I've still got about 20 minutes, I think. So now let's talk about trusts, right? The last two things, trusts and entities, right? And asset protection planning goes in sort of a continuum. You start with the easiest stuff. You take the low-hanging fruit. You use the exemptions, okay? So you protect everything that you can protect from by the use of exemptions. You then protect what you can protect by ownership in a spouse, in a QTIP, in tenants by the entireties. And then you step back and say, what do I have left? Okay, what else is exposed? What am I concerned about that a creditor might get? And then we go to the next two items. We go to trusts and entities and see what we can do to protect those other assets, right? A lot of people stop right there. We never have to get to any of the other things because the exemptions and the ownership were able to pretty well protect assets right there without having to go further. But for a lot of people, that doesn't work, particularly unmarried individuals. Okay? So we have to look at trusts. Trusts come in a variety, okay? And it's probably one of the most confusing things. We have got revocable trusts and irrevocable trusts and trusts that have lots of separate uses. And so trusts can be very confusing. For this purpose, right, we want to distinguish between first of all, a revocable trust and an irrevocable trust. Because a revocable trust is a trust that a lot of people create in Florida in order to avoid probate. Great idea, okay? Just make sure that you understand has no asset protection feature to it at all. Any assets that are in a revocable trust are subject to the claims of creditors of the person who created the trust because they can revoke it, amend it, get it all back. It's their asset, okay? And at death, any assets that were in that revocable trust are also liable for the claims of the probate estate, creditors of the probate estate. So revocable trust is not an asset protection vehicle. Good for other things, but not asset protection. Irrevocable trusts, on the other hand, are something that we do use in order to save assets from creditors. But for this purpose, it's important to distinguish irrevocable trusts into two categories, right? Something that we call self-settled trusts and third-party trusts. And the difference is a self-settled trust is nothing more than a trust that somebody creates and has themselves as a beneficiary. They can benefit from the trust. I put my assets in an irrevocable trust and I'm one of the beneficiaries. That's called a self-settled trust. And under common law, self-settled trusts are not protected from my creditors. To the extent that I have an interest in that trust, my creditors have an interest in that trust. And certainly under Florida statutory law, that's the same also. Self-settled trusts in Florida are not protected. All right. And we're going to come to the law of some other states in a few minutes that shows that how they can be protected in other states. Third-party trusts are trusts that are created by somebody for the benefit of somebody else. I create a trust, an irrevocable trust, for my child. Okay? That's a third-party trust. Okay? That trust, if drafted correctly, can be extremely protective of the assets in that trust for the use of the beneficiaries. In fact, I teach the estate planning class up in Gainesville in the graduate tax program at the law school. And since 1989, I've been saying this very corny thing. and I have students repeat this back to me, students of mine from 25 years ago will say, the 11th commandment, so the first day of class, I say, there's an 11th commandment. And the 11th commandment is, thou shalt always leave everything in trust. Okay? Because trusts are very protective. A well-done third-party trust will protect the beneficiaries from creditors of the beneficiaries, from divorce settlements, can also save estate taxes. Right? And so third-party trust, irrevocable trusts are a very important component of asset protection planning for us. Right? And that's because they have two different features. These third-party irrevocable trusts may be a spendthrift trust, they may be a discretionary trust, or they may be both. What are those? A spendthrift trust is a trust that in the terms of the trust itself, it says creditors can't reach these assets. Creditors of a beneficiary cannot reach the assets inside the trust. They can't come and say, trustee, your beneficiary, John Doe, owes me money, give me the trust assets. Doesn't work, okay? But likewise, the beneficiary can't assign or pledge or sell their interest away. It has to be restricted. Okay? So just like the creditors can't get it, the beneficiary can't go and sell it. It's a two-sided there. Spendthrift trusts are very protective. What's a discretionary trust? A discretionary trust, which can be a spendthrift trust or not, is a trust that says that the trustee has total and absolute discretion about making distributions, okay, out of the trust for the benefit of the beneficiaries. Right? There's no mandatory distribution. There's no automatic entitlement. General rule with trusts are if a beneficiary is entitled to something, his creditor is entitled to it, and his ex-wife is entitled to it as well, okay? And so if you have a discretionary trust and a discretionary spendthrift trust, you have the best protected trust possible because a beneficiary has no entitlement. They can't go to court and say, trustee, you have to give me something, all right? I need money. You've got to give me money. They can try, okay, but it's not going to get them very far. And because they can't, their creditor can't. So it's very protective. I'm skipping. And I'm simply going to note that there are some issues with respect to what we call exception creditors. Exception creditors are an ex-spouse or a child who has an alimony or child support obligation against a beneficiary. The law is a little queasy right now in Florida as to whether a trustee is required to make distributions for to satisfy alimony support. And we thought that we had that resolved, but a case just came out this year, or actually last year, the Berlinger case, told us differently. And so we're actually working on probably another legislative fix to close that loophole. And that doesn't mean that the assets in the trust are subject to a divorce settlement. It means that it is possible that a trustee might have to pay alimony or child support before they can pay a distribution to a beneficiary. Not if we get the law changed, okay? Right now it's a little up in the air. All right, so to finish up with trust, because I got to get to entities, because they're extremely important. We said in Florida, self-settled trusts are not protected, okay? If I create a trust for myself, the creditor of me can get the assets, whatever I could get, the creditor could get, right? Well, there are 16 states that have what's known as domestic asset protection trusts, where they've changed that rule. And self-settled trusts are okay. There's a lot of restrictions and rules about them. I'm not even close to it. Come on, okay, sorry. If you're able to do one of those in one of these 16 states, and the granddaddies of these, they started back in 1997 with the first state, and that was Alaska, Delaware, South Dakota, Nevada. Those are the big four that do it. And if you create a trust there, and you're a resident of that state, and you meet all of the requirements, you can't have an existing creditor when you go to do that. You got to do it in advance, right, then you can have an interest in the trust yourself and protect it from your creditors. The big question is, can residents of Florida or a state that doesn't have one of these, that doesn't approve this, the other 34 states, can a resident from Florida go to Alaska and create a domestic asset protection trust and protect against their creditors? That is a huge unknown. That's the question we've been asking since this first happened. And there have been some cases recently that have led us to believe that might be a bit of a problem. I will, in the interest of time, just point you to these cases, the Huber case and the Mortensen case. And so it is possible, okay, to still do this. You've got to be very careful about it. And it is not for the risk averse, right? But if you have no other options, okay, it might be something that you do, because the idea is, well, you know, if it's going to go to, I'm pretty sure I'm going to have some creditors down the road, and it might go to a creditor. Maybe I'll try one of these and see. Again, it's not the first line, second line, or third line of defense, but it is certainly something that you might want to consider. And what about offshore trusts? Okay. Offshore trusts, we've all heard about people who take their monies offshore, right? Cayman Islands, Turks and Caicos, all those islands we've never heard of, like the Isle of Man, Cook Islands, and you know, people will create trusts that are self-settled trusts in those jurisdictions, with the idea that the U.S. creditor has a very hard time getting the assets out of the trusts that are created in those jurisdictions, and that's because when you're in the United States and somebody from Florida has a judgment against somebody who lives in Georgia and has property in Georgia, all you have to do is walk up the street, walk up I-4 to Georgia, to a court in Georgia, and you can say, he owes me money, and you get the property in Georgia. It's called full faith and credit article of the Constitution. That's not the way it works when it's in an offshore jurisdiction like one of these. You actually have to reestablish the debt. So if you had sued somebody here and gotten a judgment against them, you could enforce that judgment in the United States, but if they've got money in an offshore trust in the Cayman Islands, you have to go down there and sue all over again, okay, and determine whether you're entitled to it. And oh, by the way, most of those offshore trusts have what we call flee clauses, which says that the trustee can move it to another jurisdiction if they want to. So if the creditor goes down to the Caymans and starts the lawsuit to try and get the money, okay, then they just move to Turks and Caicos, okay? So now the creditor has to go to the Turks and Caicos and start suing them there. And then they move to the Cook Islands, right? And so has to be somebody who really is owed a lot of money and has a lot of resources to go to all that trouble. And that's why the thought is that these offshore protection trusts actually will work. But the problem is United States courts hate them. Okay, they really do not like the idea of offshore trusts. And so they will do things like jail debtors, okay, on contempt charges, because they will say, you have the person who created the trust, you can repatriate those assets. We know you can. We've read those trusts. You can bring them back into the United States, and until you do, you can sit in jail, okay? And that's happened. There have been some very big cases like that. And if there happens to be any property left in the United States, okay, the state courts are not terribly receptive to offshore trusts. So the assets that are actually down in Turks and Caicos might be protected. But if you got some real estate in the state of Florida, not going to think that's going to be terribly protected. Okay. It's a very good possibility a Florida court is going to award a Florida creditor the assets that are actually in Florida. All right. So now let's look at entities. All right. We've got a little bit of time, and entity planning is extremely important. And we have to start with, and I'm sorry, I need about 10 more minutes, guys. I'm probably going to run over a couple of minutes, but this is an important thing. So entities are one of the big things that we do, if you have businesses or if you even have rental real estate, okay, that we are concerned might generate liability, right? You're making widgets. Somebody might use the widget and get hurt, okay? Or you might have commercial real estate and they slip and fall and get hurt, right? We're concerned about that liability. We're concerned about it from two sides. We're concerned about the liability, and we call this inside liability, that is generated by the business itself, by the business or the property itself, right? And we would like to protect our personal assets, okay, from business debt. Right? So we've got this rental property and we've got this huge brokerage account over here that's in our name alone, right? If somebody falls on the property, it's one thing to say, I'm going to take the property because, you owe me money. We certainly don't want them to be able to go over and get the assets that are in the brokerage account. We want the business liability to stay inside the business, okay? Not go outside the business. We're also concerned about outside liability, right? So now we've got this great business, fabulous, wonderful business with lots of assets, and the owner of that business has a car accident, takes out a school bus, and has huge amount of debt, judgments against them, right? We don't want the outside liability to come and be able to use the business assets to satisfy the outside liability, right? So we're trying to protect inside liabilities and outside liabilities. The other concept that we have to understand to get how all this works is something called the charging order. And a charging order is a special right that we would like to have apply to interest in businesses, and only a charging order. Because what a charging order says is that in my example of the owner of the business had a car accident, okay, and owes person X a whole lot of money. We don't want him to take the business away though, okay? We don't want them to be able to just come and take the stock, okay, of the business, or to be able to force a sale of the business or the assets of the business or in liquidation of the business, right? Right? So if we've done our homework and we do things correctly, the only thing that outside creditor can get is what's known as a charging order. And a charging order says that all they can get is the right to stand in the shoes of the owner and receive distributions that are made. They can't force distributions. They can't force a sale. They can't force a liquidation. But if there are distributions of profits that are made out to the owners, whatever is distributed out to the person that owes them money, the creditor gets. Right? They have no rights to manage the company at all. They have no rights to force a liquidation or a sale. All they get is whatever distributions that person is going to get. And of course, we would hope that we have a little control over that issue. And maybe we don't make distributions. Maybe we pay higher salaries or management fees, okay? And we reinvest profits, okay? And we're in charge of that because a charging order creditor doesn't have any rights to management. Okay? So we would like to end up with a situation where all they can get is a charging order. Right? So when does a charging order apply? All right? Charging order applies when the business is owned as an LLC or as a limited partnership. Okay? Right? So if we have, and LLCs are now sort of the preferred method of doing business in Florida. It didn't used to be, because before 1998, there used to be a corporate income tax on LLCs. We got that repealed. And now LLCs are the preferred way of doing business. They're can be taxed as a partnership. Okay. Or as an S corporation, as you choose. But it is an entity. Right? And so let's start with inside liabilities. Right? How does an LLC and a limited partnership protect from inside liabilities? Well, that's because it's basically the owner of the LLC interest is not liable for the debt of the business. Okay? The debt of the business does not come out to a limited partner or to an owner, an LLC, an owner of an LLC membership interest. Doesn't come out to an owner of an S corporation or a C corporation stock owner either, right? But as you'll see in a second, that's not as good as an LLC, right? So we've contained the liability inside the corporation. They can get the assets that are inside the company, but they can't get our big brokerage account that's over here, okay? Then how is it protective of the outside liability? Well, an LLC, if it is a multi-member LLC, meaning there's more than one owner, not a single member, but a multi-member LLC, or it's a limited partnership, okay, they can only get this charging order. They cannot come and foreclose the interest. Right? Now, if it's a general partnership, they can, right? Excuse me. Or if it's a single member LLC, I give up. They can also do that because the idea behind what's the rationale behind the charging order? You've got to realize what that rationale is. The rationale is that we've got people in business. We've got 3 or 4 people who are in business together. And one of them is stupid and goes and drinks too much and kills people and has a big judgment, right? If they're able to come in and force a sale of the business or a liquidation or distribution, who does it hurt? It hurts the other owners, okay, who did absolutely nothing wrong. So the idea behind a charging order is we're going to protect the business. We're going to protect the other owners. Right. We're not going to let the business be sabotaged because of the liability of one of the owners. Okay? Whatever comes out of that business to the owner, that creditor can get, right? But they can't come and take the business itself. Well, if you've got a single member LLC, who else is there to protect? If you only got one owner, right? So the Supreme Court of Florida said a few years ago, single member LLCs, not much protection. So if we want to go down this path, we want to have multi-members, and we want to have a limited partnership. Now, why, in the few minutes that I have left, why is an S-corp not as good? Okay? It clearly protects from inside liabilities. Okay? It will keep the assets inside, the liabilities inside the entity, and the owner is not liable for the debts of the business. But the charging order concept does not apply to stock. It only applies to LLCs or partnerships. Okay? And that means that if I own a majority interest in that S-corp, I have 51% of the stock, okay, then my creditor can come and take my stock. They don't just get a charging order. They get to take the stock itself, which means what? They're in control of the business now. They can sell it, make distributions, liquidate the business, etc. So from an asset protection standpoint, S-corps and C-corps, not as good as LLCs, right? Or limited partnerships. And so what can you do if you've got an S-corp out there? You can actually convert to an LLC, and I give up. You can convert to an LLC, and in order to avoid any tax liability when you do that, you just have the LLC elect to be taxed as an S corporation. And so you have your cake and eat it too, right? Okay, and so now let me just show you this. I'm going to end with this. One of the things that we've been talking about with entities is that we want to keep the liability inside the business, right? We want to protect the outside assets from the liabilities of the business. We want to protect the outside or the inside assets from the outside liabilities. Well, if you have a situation, and this is actually from the presentation I did last year, when we were talking about business succession, you've got this owner owns 100% of Ag Company LLC, and in this, and it's about 95% of all of his assets. And he's got trucks and equipment and cattle and citrus and real estate, some commercial real estate. He's got it all in one big company, okay? And he thinks he's in great shape. Well, he's not in good shape, is he? First of all, it's a single member LLC. So that's not good because an outside liability can be a problem here. And why is it not such a great idea here? Because we've combined a lot of value with some things that can cause liability. We got the pick and haul deal here owned in this company. And what if the driver on a Friday afternoon decides to have a liquid lunch and takes out that school bus? Now you've contained the liability inside the company, right? But they got everything. They can get the real estate. They can get the citrus. They can get everything that you own inside this because of one little problem. So what's a better way to do it? A better way is to do this, and that is to segregate lines of business into separate entities. So you separate out operational liabilities. So now what we did is we've got a holding company, essentially, that owns it. And then we dropped down into separate LLCs. The trucks and the drivers are over here. And then we've got the citrus in one. We've got the cattle in another. We've got the commercial real estate in another. And that's good for business succession purposes also down the road, but it's really good for liability purposes. Because now when that truck driver goes out and takes out that school bus, what can he get? What can that creditor get? Can only get the assets that are in AGCO Trucking LLC. Can't get the real estate, can't get the citrus, can't get the cattle, right? Because we segregated the liability into separate operational lines of business. Right? So we've protected the rest of the assets. And that's what a lot of people do. You won't see a real estate developer who has all of their assets in one big entity. They will have a separate entity for every single development they do so that they can segregate out liability and maintain assets separate if we have a problem. And I would just caution you that when we're talking about doing asset protection, we have to be careful that we don't do any fraudulent conveyances or fraudulent transfers. If we've already got a creditor out there, it's a little late, okay? Because it's difficult, very difficult to do good asset protection planning when you've already got a creditor, because anything that you do might be thought to be a fraudulent conveyance where you're trying to hinder, defraud, or delay a creditor. So the time to do asset protection planning is before you have any creditors. Okay? You plan in advance. So last is a summary. What do we do for asset protection planning? Well, first of all, we have adequate insurance. We take advantage of exemptions, all of these exemptions. We then protect assets through ownership, tenancy by the entireties, maybe spouse, maybe trust. Then we can actually create spendthrift discretionary trusts, right? And we use entities. And with that, I think I've gone over by a couple of minutes, about 5 minutes, I'm sorry. I will stay after if anybody has any questions, but I believe that this is it for the day. Does anybody want to say any final words to the group? Okay, she's going to do that, but I'm done. And I'm sorry for this mess here.